in so many of these prior cases, there was a cooperation. For example, tax returns. Every president voluntarily turned over his tax returns. So it gets to be a pitched battle here because President Trump is the first one to refuse to do that. And initially he said because of an audit was ongoing. Now it seems to be broader than that. But the aura of this case is really sauce for the goose that served the gander as well.
We've never had to address this issue, and the reason is because Congress and the President have reached accommodations with each other, and sometimes one has gotten more and sometimes the other has gotten more, but there's always been this accommodation seeking. And what it seems to me you're asking us to do is to put a kind of 10-ton weight on the scales between the President and Congress, and essentially to make it impossible for Congress to perform oversight and to carry out its functions where the President is concerned.
And the question then boils down to how can we both protect the House's interests in obtaining information it needs to legislate, but also protect the presidency? How can the court balance those interests?
But in your view, there is really no protection against the use of congressional subpoenas for the purpose of preventing the harassment of a president, because the only requirement is that the subpoena be relevant to a conceivable legislative purpose, and you can't think of a single example of a subpoena that wouldn't meet that.